Good evening, one and all. I am Professor Sandeep Desai, Dean, Faculty of Law, PESU University, Bengaluru. Let me extend a very warm welcome to all of you for this PESU Law webinar series starting from today. Friends, Faculty of Law, PESU University, Bengaluru is a young department successfully completing the third year of its academic odyssey. Having been established in the year 2017, Faculty of Law is blessed with the guidance of Honorable Justice Shri M.N. Venkatachalaya as Chairman of the Faculty Advisory Committee and is fortunate to be led by Professor Dr. M.R. Doreswamy as Chancellor, who is also the Chairman of the Education Reforms Committee of the Government of Karnataka. Ever since its inception, Faculty of Law has been striving relentlessly for the cause of legal education, and it has left no stone unturned in its endeavors. As part of the same, from today, we have started webinar series, and in this inaugural session, we are joined by Shri S.P. Shankar, Senior Advocate, an advocate of more than 50 years of practice, an advocate of great academic bent of mind, a prolific writer, a person who is possessed with oratorical skills and persuasive qualities. Today, Shri S.P. Shankar would be speaking to us about the content, context, and contours of Article 370 of the Constitution of India, read with Article 35, capital A. I am sure you must have already guessed what the topic he is going to hit upon. And without wasting much of the time of all of us, let me request Shri S.P. Shankar, designated Senior Counsel, to address us all in this inaugural webinar. Sir, I am handing over this to you. Thank you.
Good evening to all the participants and the faculty members who are present here. Constitution of India was brought into existence with great efforts and unending participation of leading advocates and scholars holding position of great importance in legal education. Not only the Constituent Assembly sat for continuous number of days, it deliberated on several issues in bringing out the present form of Constitution. When I say present form, the date is 26 November 1949. After the Constitution came into existence, we have seen several amendments effected to the Constitution, virtually changing its form, content, and implications. We are not going into the other details of Constitution except to discuss various aspects of Chapter 21 of the Constitution of India. As one could see, the title to Chapter 21 is stated as temporary, transient, and special provisions. When the Constitution was drafted and brought into effect, the Chapter 21 read as merely special provisions or urgent provisions. Temporary provisions was not there. When Constitution was amended, this addition came into vague. By a look at this heading of the chapter, you will notice that the provisions are temporary, provisional, and transitory. In order to bring about transition of power, certain arrangement has to be made, and because of this legal necessity, Article 370 was conceived and put into effect. Initially, provision like Article 370 was not in the draft constitution, and it occurred to the men in charge of administration that there should be an article making departure from the regular application of the constitution and for providing special provisions uh, in terms of the draft that was placed for consideration. The committee did not show any interest and on the other hand declined to make a provision like present Article 370. After great persuasion, Constitution Constituent Assembly considered the need and justification for introduction of an article like 370. It is in this forum Article 370 came into existence. In a few years' time, it was found that there has to be smooth transition of power and that therefore there has to be named as temporary provisions and not a permanent feature of the Constitution. It is in this manner the present Article 370 exists. For the day's discussion, we have another provision of law, in proclamation made by the President under any of the provisions is also law, and therefore I would call the promulgation made by His Excellency the President of India as law, namely Article 35A. In fact, Article 35A is not found in the book of the Constitution or text of the Constitution. It is an executive order or a constitutional order signed by the President of India. We will have to go into the kinetics of formation of separate state of Jammu and Kashmir for this purpose. State of Jammu and Kashmir was earlier a princely state, and Hari Singh was the Maharaja, and he was the head of that state. There were 500 odd states in India, and in order to unify them, some measures had to be taken, including drastic measures. Jammu and Kashmir came into the fold of India voluntarily by the Maharaja of Jammu and Kashmir. Maharaja Hari Singh entered into an instrument of accession, thus making Jammu and Kashmir a part of the territory of India. Article 1 would say, this is India, comma, Bharat, and the Constitution of India is intended to help and assist the development of the country. It is significant to notice that Article 1 is made applicable to the state of Jammu and Kashmir right from 26 January 1950. While several provisions of the Constitution are not and were not made applicable to the state of Jammu and Kashmir. 370 gives a special status to the state of Jammu and Kashmir. And it's significant to notice that Article 370 is not an isolated provision of the Constitution. There is a similar provision addressed to other states like Article 371. 371 has several provisions which would apply to the enumerated states, including the University of the central government in state of Andhra Pradesh, state of Uttar Pradesh. So you will Andhra Pradesh and Telangana is the latest in in being added to Article 371 clause B. In addition to Article 370, we have 35A, as I said earlier, constitutional order. This Article 35A provides certain protection to the citizens of Jammu and Kashmir. And it's interesting to go to the text of Article 35A to know what it is. It defines who is and who is not a permanent resident of the state, to determine as to which people are in or outside the state will have special rights and privileges granted with the state. 35A enables the Assembly of Jammu and Kashmir to determine the recipients of state grants the right to purchase land, property in the state, as well as settling permanently in the region, to restrict rights of any person not classified under permanent resident of the state. The Article 35A proceeds further to define the classes of persons who are permanent residents of the state, their restrictions or rights in the matter of employment, acquisition of property, settlement in the state, right to scholarships, and other forms of aid, and the like. And it would conclude that it should void on the ground that it is inconsistent with any of the religious rights. In sum, Article 35A confers huge privileges and rights to the residents of Jammu and Kashmir to the exclusion of others similarly situated in India. Nobody else can purchase land in Kashmir. Nobody can marry a Kashmir girl. These are all the consequences of Article 35A. They had no obligation towards the state in that they had their own constitution and their own way of life and culture. These things started brewing sort of discontent amongst others. And they had a national flag. They had their own constitution. They had their own courts. They were not bound by the rest of the law in India to a large extent. These situations apparently virtually conferred unjustified privileges on the people of the Jammu and Kashmir. Article 370 purported to confer huge benefit on them, though the parliament was required to make law for the state of Jammu and Kashmir, as if the field of legislation was in list 3. The situation developed that they refused to respect the national flag and or hoist the national flag on national important days. a situation obtained that anything that the central government did was not to the liking of Jammu and Kashmir. As long as the political bosses in center and in the state were one and the same, there was no difficulty. When the administration at the center and at the state were different, the friction started. I, I think I can now come to the brighter aspect of the issue, namely how 370 is made ineffective or is defanged. Article 370 is not removed, is not deleted from the Constitution as some think. It is a matter of record that Article 370 continues to be in the book, in the Constitution, and its impact is altered. The effect of Article 370 is diluted. We see that Article 370 has three clauses 1, 2, and 3. Article 373 mandates that if the President, by reason of a proclamation, makes any law, it shall have effect, notwithstanding the provisions of the Constitution, Article 370 itself. Number of times, the Article 370 has been meddled with without any demur. It is true that first one of the Union of India was challenged in the Supreme Court, and the law laid down in Sampat Prakash for the state of Jammu and Kashmir holds its field even today. That is AR 1970 SC 1118. Then we have I think not earlier to this, we had another decision in Premnath Kaur versus State of Jammu and Kashmir, AR 1959, SC 749. The summoned effect of the decision in Sampath Kumar is the President has the power under Article 373, Clause 3, to make any altered situation or effect serious change in the scheme of the scheme of Article 370 itself. And we all know that benefit of Article 15.4 and 16.4 were extended to the people of Jammu and Kashmir, and the people did not challenge it because it was beneficial to some. Again, Securitization Act was sought to be extended to the state of Jammu and Kashmir to ease the situation of recovery of money by banks. This was found fault with on the ground that Article 35A is contravened, and Article 370 is also diluted. The matter was taken up before the High Court of Jammu and Kashmir, and the High Court of Jammu and Kashmir accepted the challenge and held that Parliament cannot make law or extend the administration of justice by extending the provisions of Securitization Act to the state of Jammu and Kashmir. The State Bank of India was the aggrieved party, and Santosh Gupta was the borrower who said that under common law, recovery has to be made and law of limitation would apply, and the benefit of seeking installments and other benefits are taken away. This was the subject matter of decision of the Supreme Court, since reported in AR 2017 SC 25, and also reported in 2017 3 SCC 538. Paragraphs 16 to 27 of this decision is worth reading not once but many number of times. Scope of Article 370 is discussed threadbare by referring to the earlier decisions holding the field and deducing the situation that Union of India has the power to alter or amend or even delete certain provisions of Article 370 itself. Now comes the political scenario. A few years ago, Jammu and Kashmir was ruled by a coalition government. The coalition was between two political parties, and that political party had not seen the in and out of the boiling kettle of politics in Jammu and Kashmir. By associating with other regular political team in Jammu and Kashmir, the new entrant to the politics of Jammu and Kashmir observed keenly and noticed the pulse of the people. It occurred to that other political partner to think in terms of using Article 373 to its advantage. Then came the declaration of presidential rule and keeping this assembly under suspension or suspended animation. In this situation, the president introduced certain new law, including amendment of 15.4 and 16.4, as well as declaration under 370 clause 3. It met with success, and slowly a beautiful move was made to say that the power of the Constituent Assembly, which is a primary, which has a primary role in dealing with Article 373, is vested in the governor. This was the first step, and this went unchecked or unchallenged. The situation was that the state of Jammu and Kashmir was under really a transition in terms of Article 370. Constituent Assembly and its powers is replaced or was replaced by the institution of the governor of the state of Jammu and Kashmir. His consent was a substitute for the consent of Constituent Assembly required as primary consideration under Article 370. Then on one day, that is on 5th August 2019, President of India issued a proclamation that in terms of Article 370 clause 3, the effect of Article 370, the rigor of Article 370, the standing, the aspect of 373 is undone. In other words, Article 370 was virtually defanged. 35A lost its efficacy. Article 370, which gave a definite role to state of Jammu and Kashmir, became one with other states in the Union of India. The situation became normal, and the special status Jammu and Kashmir enjoyed saw its terminus. Well, then we'll have to go to the legal aspects. Article 370 is not a permanent provision of the Constitution. It is only a temporary or a provisional article which was intended to facilitate transition of power in terms of the Constitution of India. we had to see that this power was not was not hindered or countered by any other institution other than the Constitution of India. The situation developed in such a way that instead of the status of Jammu and Kashmir, the present situation it has become unit of the central territory or union territory. Now, look at the transmission of the status of Jammu Kashmir. Instead of being a state, it has become a state unit, and it is split into three parts: Jammu, Kashmir, and Ladakh. Leh is also a part of it. So, Ladakh, there was no representative. In Srinagar, there was no representative. We had a split assembly, leaving permanently for all times up till now those 17 or 18 MLA seats vacant, unoccupied, and uncontested. Because there was no contest. So the situation is this: Jammu and Kashmir, state of Jammu and Kashmir, is now a unit of the union territory, and instead of having one state of Jammu and Kashmir, we have three units, and Ladakh has a representative who made his maiden speech in the parliament and made a huge impact and made everybody sit alert, sit tight and alert and listen to him. His speech can be recalled to say that equality was unknown to us, and equality, which is found in Part 3 of the Constitution, was never enjoyed by others, and we have tasted it. His speech is recorded and often played in Rajya Sabha proceedings, and it appears that everybody is happy with this situation. Then we'll have to go to this judiciary. Earlier, the autonomous state of the judiciary was partly in force, and sort of superintendence by the Supreme Court was also in place. Say, High Court of Jammu and Kashmir, the judges were posted earlier from amongst the members of the bar, and later on the Supreme Court, the Collegium of the Supreme Court, through His Excellency the President of India, appointed judges. There was no transfer in the earlier stages. When transfer came, the judges from other places have been now residing in Jammu and Kashmir and are working as judges of that High Court. Law has found its own level, and law is found to be operative in the state of Jammu and Kashmir, though not as a state, but as the central units of union territory. They have the provisions of the constitution of the Jammu and Kashmir are not abrogated wholly. Parts of it are raising issues, and several issues had remained unsolved for some time. Thanks to the latest the political, I don't know what word I can use, exercises, we have a different situation, and the political scenario has changed from one now administration by a few families has now gone to the members of the larger the aspect of central administration as far unitary states are concerned. The situation is changed both in terms of the constitution and politically. a small diversion, if permitted, and we'll have to see what was the scenario in state of Jammu and Kashmir 1 year ago or 2 years ago, and what it is now. Peace has settled, rule of law exists, and administration is in the pink of health. This situation is the outcome of defanging Article 370 and diluting Article 35A. Kindly see the effect of Article 35A. People from Bombay, Ahmedabad, Gujarat, and Delhi have migrated to Jammu and Kashmir and have established business houses, hospitality institutions, and are also trying to rise an industry. Several industries are likely to come up. So this is how the political scene has changed. Now we'll have to see what is the effect of amendment or constitutional order that has taken its roots in the state of Jammu and Kashmir. I think a redo of this constitutional perspective may not be redundant. Article 369, which conferred temporarily on the Parliament to make laws, precedes Article 370. 369 had limited scope and application, and it was confined to take care of a political situation in trade and commerce. 370 was devised as a temporary provision with respect to state of Jammu and Kashmir. It, as I stated earlier, it is similar to Article 371, which dealt with and gave states of Maharashtra and Gujarat special status and privileges. But till it found its root. Then we have state of Nagaland, which is protected by Article 371, capital A. State of Assam, Article 371B. State of Manipur, 371C. State of Andhra Pradesh and Telangana, Article 371D. Establishment of Central University in Andhra Pradesh is controlled by Article 371E. State of Sikkim, 371F. State of Mizoram is governed by 371G. Arunachal Pradesh by 371H. Goa is governed by Article 371I. From time to time, temporary the powers have been invested in these states to develop in terms of infrastructure and other facilities. Now we'll have to see what is the scope of Article 373. 370 Clause 3. It authorizes the President of India to declare that 370, Article 370, shall cease to be operative or shall be operative with only such exceptions and modifications. And this authorization to the President is made subject to the other provisions, namely the consent of the Constituent Assembly and the resolution of the State Assembly to authorize the President of India. I mentioned earlier that during emergency, the political parties had an insight, a deeper insight into the affairs of Jammu and Kashmir and what was going on, and which had remained non-transparent all along. So the absence of a constituent assembly in place in view of presidential rule holding the field, there were certain adjustments made to confer on the governor the power of the Constituent Assembly. The governor gave his consent. The governor was virtually the legislature in Jammu and Kashmir, and his recommendations paved way for declaration of the notification under Article 373. Again, it is not an amendment, it's only an executive order of His Excellency, the President of India, under Article 373. Then we will have to see the scope of Article 226 in this behalf. Before we go to the Article 226, which is readily inferable from SBI versus Santosh Gupta, we think we should take note of the historical changes the state of Jammu and Kashmir evidenced right from the day of independence. A few dates are relevant. On 26/10/1947, His Excellency, His Highness, the Maharaja of Jammu and Kashmir, wrote a letter to the Governor General of India offering to accede the territory of the state to the dominion of India. On 27/10/1947, Governor General accepted the offer and made certain stipulations for accession. On 5/3/1948, Maharaja issued a proclamation forming a responsible government of a council of ministers headed by Prime Minister, which was to take steps to constitute a national assembly based on adult franchise to form a separate constitution for the state. On 20th June 1949, Maharaja of Jammu and Kashmir entrusted his legislative, executive, and judicial functions to his son Yuvraj Karan Singh. On 25/11/1949, Yuvraj Karan Singh issued a proclamation directing that the Constitution of India to be adopted by the Constituent Assembly of India should also be adopted by the Constituent Assembly insofar as it was applicable to the state of Jammu and Kashmir. This was in order to govern the relationship of the state and the contemplated dominion of India. On 26/11/1949, Constitution of India was adopted and certain provisions came into force on that day. The remaining provisions came into force on 26/1/1950. On 26/1/1950, Constitution application to Jammu and Kashmir order, that is Constitutional Order number 10, was issued by His Excellency the President. On 20th February 1951, Maharaja issued a proclamation convening the Constituent Assembly on 5/11/1951. On 10/6/1952, Basic Principles Committee of Jammu and Kashmir Constituent Assembly submitted its interim report and recommended a few aspects, namely, form of the future constitution of Jammu and Kashmir shall be wholly democratic. The institution of hereditary rulership shall be terminated, and the office of the head of the state shall be elective, or should, I don't know, that it should be selective. On 12/11/1952, the Constituent Assembly of Jammu and Kashmir adopted these recommendations and passed suitable resolutions. On 15/11/1952, President of India made an order, Constitutional Order number 44, amending the explanation with modification, whereby instead of Maharaja of Jammu and Kashmir, it would be Sadar-e-Riyasat of Jammu and Kashmir would be the head of the state. On 14/5/1954, President, with the concurrence of the government of Jammu and Kashmir, made the constitution applicable to Jammu to Kashmir, Order 1954. This superseded the earlier order made in 1950. Then on 17/11/1956, Jammu and Kashmir constitution was adopted with some sections coming into force. These aspects are dealt in great detail by Supreme Court in AR 1972 SC 963. Then we had the appearance of Sardar Vallabhbhai Patel into the political arena. His main theme was to produce, retain, and maintain an integral part of sovereign democratic Republic of India, and Jammu and Kashmir be annexed to the dominion of India. This happened in part, and several parts of constitution were made applicable, and a few were not made applicable. Then Article 35A assumed some relevance and importance because it conferred huge privileges on the state authority or rulers. This gave rise to political discontent and the secrets of administration, and the authorities who held the power came to limelight, and people other than residents of Jammu and Kashmir started evincing interest in the administration of Jammu and Kashmir. And this is how we have the whole scenario, as a result of which we have Jammu and Kashmir as a union territory instead of being a state, and its integral part never to be parted with. I think that this discussion will enable the country to sit up and see whether any inadequacies in the parameters of administration and what is required to be done to see that the territory of India is intact and remains integrated and never violated. Thank you.
Thank you, sir. It was indeed a pleasure to have been listening to you and your distinguished discourse on Article 370 read with Article 35A. I have a couple of questions received by the participants in this webinar. One of the questions is this: what would be the status of those legal proceedings initiated before the repeal of Article 370 and the allied legislations along with that?
General Class Act would apply, and unless the promulgation under Article 373 touches or refers to those judgments and passes any adverse remarks or tries to dilute it or hold that they are not applicable, they are valid and they are saved by the provisions of the General Class Act and would apply and will continue to hold the field.
Sir, there are other slew of questions actually, a few questions. Let me just read them one by one, sir. The first question is, was Article 370 used for the delegation of power as it was originally intended to do for a vulnerable population who were insecure about their identity and their culture? The second question is, did the logic of ethnic nationalism damage the fabric of secularism? And third one is, did Article 370 recreate power structures as it was intended to, or did it just add another level of trick to the existing biases in the society? So the first question is with regard to delegation of power as it was originally intended to do for a vulnerable population that were insecure about their identity and their culture.
The written version of the question is there?
Yeah,
I'll have it.
You can.
The question is loaded. I do not know who the vulnerable people refer to in the question. It enables me to think that they could be persons who are driven out of their territory, or the very same people who were the loyal citizens of the Maharaja, and they are to be treated as vulnerable people. Anyway, whenever there is any change in the political scene, that is transformation from the rule of Maharaja to the rule of democracy, the necessary consequences will follow. The Constitution has provided enough safeguards to them, and Part 3 of the Constitution has always been applicable to people of Jammu and Kashmir. They did not feel aggrieved by the provisions of Article 373 or its exercise of power by the President of India. And one or two occasions they had tested, and the questions had been answered against the persons who had challenged. Say in Sampath Prakash, Ranjit Kaur, and latest in SBI versus Santosh Gupta. The resultant situation is law has taken its course. The change of law brought about change in the form of government. Administration of law has not caused any prejudice to the people of Jammu and Kashmir. If it is a question of rehabilitation of those who were sent out of it, now serious efforts are made to rehabilitate them. This answers first question. Did logic of ethnic nationalism damage the faculty of secularism? Nationalism and secularism do not belong to one domain. Nationalism is an abstract thing which a citizen of India develops as respect to his nation or her nation. Secularism is a personal thing, and fortunately, neither nationalism nor secularism is defined in the Constitution. It occurred to the person in the government in power to amend preamble of the Constitution to introduce secularism. The objects of amending the preamble does not spell out the reason for introduction of secularism, and secularism is the mother of all of issues that pervades now. Nationalism, fortunately, is covered by Part 4A of the Constitution, and nationalism is to be inculcated by everybody, and it is considered as a duty of every citizen in terms of Part 4A. I think the third question is, did Article 370 recreate power structures as it is intended to, or did it just add another level of pick to the existing biases in society? I refrain from answering.
Sir, thank you. There is one more question. In retrospect, and especially in light of the present legal developments, legal and constitutional developments, do you think this Kashmiri issue was more a geopolitical issue than a religious one? One of the members of the audience wants to know this.
It's more a geopolitical issue. Importance of the state of Jammu and Kashmir has to be realized and made a part of our administration in view of the three neighbors we have on north, east, and west. We have suffered loss of land in the form of what is it called?
Aksai
Aksai chill. We have lost land in Nagaland. We have lost people at the POK. So therefore, it has its own nuances and dimensional impact on the rule of law. This is a struggle going on to keep the balance, and we have not found a solution. I don't know whether we find a solution or a new problem adding to the existing problem.
Sir, another question that a participant wants to ask is this. Is there any obligation on the part of India to conduct a plebiscite in Jammu and Kashmir as part of the Security Council resolution made earlier? So where do we legally stand? What is our legal position?
Plebiscite is a decided issue when Krishna Menon successfully and effectively argue and help United Nations to pass as a resolution insisting that Pakistan should vacate POK, and then by bilateral talks the issue must be resolved. Plebiscite is not a lingering issue, and plebiscite is not the solution. Plebiscite was insisted on the ground that people would decide and it would result in self-determination, giving a go-by to the accession made by Maharaja Hari Singh. The accession to India has become irreversible. If this version is accepted, plebiscite has no legs to stand. Plebiscite is a lost cause of our neighbor.
Sir, I also have one question. Notwithstanding all the legal and other political arguments made on behalf, in favor, and against this proposition, especially about Article 370, what do you think is the jurisprudential view of inserting Article 35A by virtue of an executive order? Because amendment to the Constitution, as we all know, could be done through the formal procedure laid down in the Constitution itself. So how do you think, especially with regard to Article 35A and its bringing in through an executive order? I mean, purely academically and jurisprudentially speaking, what is your take on this?
The answer is found in the question itself. In the sense, 35A is not a constitutional provision. It's a constitutional order. It's an executive order. By reason of numericals, 35A must be found in Part 3 of the Constitution. 35A is not found in the Part 3 of the Constitution, and it does not confer any fundamental right. Fundamental right in terms of Article 14, 19, 21 has to have different color, different contour, and different connotation. 35A, as authors of the Constitution have referred to, with reference to the constitutional order passed in the year 1950, it is an executive order not a product of Article 368. Constitutional provision cannot be taken away or loaded with further explanations except in accordance with Article 368. 368. 368. Yes. 368 has not been followed while bringing constitutional order under Article 35A. Thus, therefore, Article 35A, neither being a basic feature of the Constitution nor a permanent feature of the Constitution, cannot be treated at par with basic structure in terms of Keshavananda Bharati or the subsequent decisions holding the field. The situation is 35A was created by executive. It is undone by the executive. 35A was a constitutional order. 370 cross 3 order is also a constitutional order. One squares off against the other.
Well, thank you, sir. Thank you for giving us a wonderful start to this PESU Law webinar series. And on behalf of the PES University and Faculty of Law, PES University, let me place on record our sincerest gratitude to you. And let me also thank you, audience, the members of the audience, for having attended this thought-provoking lecture by Shri S.P. Shankar, Senior Advocate. Please do join us in the evening again at 7 p.m. We would be having with us Honorable Justice Shri V. Shri Shananda, Judge, Honorable High Court of Karnataka, who would be deliberating upon the analysis of rights, a purely jurisprudential aspect. And I'm sure it would definitely be a feast to, a virtual feast to listen to, as well as to see him, see his lordship in action over this subject. So thank you one and all for having joined this.